We don't want you owning assets when you die. We want your trust to own all of your assets. And in today's video, I'm going to break down the different ways you hold title to different assets, from real estate to LLCs to retirement accounts to bank accounts, investments account. I'm going to break down the different ways you transfer and hold ownership of your assets in your trust. Now, this is part 2 of my 4-part estate planning masterclass series. I'm Matt Sorensen. Let's build wealth. Now, the best way to understand this is to just go asset category by asset category and break down how you're going to take ownership to those assets in your trust. So let's start with your trust here. I'm going to whiteboard this out. Now, this is your trust that you have for estate planning purposes. This is a revocable living trust. That's what we set up in our law firm for clients across the country. That's what most people should have, is a revocable living trust. If you've heard about irrevocable trusts and all these exotic trusts, I want you to stop, drop, and roll and go get advice from a real lawyer. Most real lawyers don't set those trusts up unless you have a very unique situation. For most Americans out there, 99.9% of Americans, you should have a revocable living trust. And we're doing this for estate planning purposes so that your assets go on to your loved ones and they don't go through probate. It's a private process. That's why we're using the trust. All right, so let's break down how your trust owns all of your assets. Now, the first thing we want to talk about is your home. This is one of the biggest assets most Americans have. Your home should be deeded into the trust. So your name should not be on the deed to your house. Your trust should be on the deed to your house. Okay, so we're gonna have a deed there on the property that is your home. This is your personal residence. What if I have a rental property? Okay, well, your rental property is typically gonna be held in an LLC if you're doing it right. And the LLC is gonna be on title to the property. Well, how do I get my trust to own it? Well, we have your trust own the LLC. So you're gonna do an assignment of the LLC interest from you personally to your trust. It's like when we set up a trust for our clients and they have an LLC, we'll help them with these assignments and we'll move the ownership out of their name over to the trust. Now, maybe you have a second home or a cabin or some land or something. It's not investment property in the sense that there's a tenant on it. That could be deeded into the name of the trust as well directly. But any investment properties, rental properties, we want those to be owned through LLCs, so the trust is going to own the LLC itself. All right, let's talk about the second biggest bucket that most Americans have where they've built wealth. That's in their IRAs and 401ks. How do I have my trust own those assets? Well, the easiest way you're going to do that is what's called the beneficiary designation. Whenever you set up an IRA or a 401k or any retirement account, the custodian has something called a beneficiary designation. This is usually on the application when you set up the account, and you designate who gets the account when you die. Now, if you have a trust, you can list the trust as the beneficiary. Now, most people are going to list their spouse first, and then they list their trust as the second beneficiary. Now, the reason most people do that is there's something called a spousal rollover for IRAs and 401ks that allows your surviving spouse, if you have a spouse, to inherit your account upon your death, and it becomes an account in their name. So, for example, if you have an IRA and you pass away, your spouse gets to just roll that money into their IRA, and it simply becomes their own account. If you don't have a spouse, you're the second to die, you can't use that. And then, of course, whoever's the beneficiary in your trust, your spouse, your kids, whoever it might be, they are going to be the ones that then inherit that asset, whether it's the IRA, the 401k, or whatever retirement accounts you may have. All right, let's talk about the next category of assets that comprises a big piece of what passes on through individuals' estates. This is your bank account, savings account, investment account, brokerage account. How do I get these to pass on, and how do I have my trust own these assets? Well, it's similar to the IRAs and 401ks. This is through the beneficiary designation, sometimes called payable on death or POD. So when you set up a bank account, same thing. You're going to list on that bank account, savings account, brokerage account, who is the beneficiary and gets the account upon your death. This passes outside of probate court, doesn't have to go through probate, and that is there where you can list the trust as the beneficiary upon your passing. All right, now the next category that also comes up often is what happens to your cars, your boats, and other assets that have actual titles to them. Do I need to update the title to have my trust as the owner? No, you do not. You do not need to go update and list the trust as the owner of your car. You don't need to do that. It's a waste of time. Your heirs will be able to go into the MVA or DMV, whatever it is in your state, to go update the ownership upon presenting a death certificate and claiming that they are next of kin. They do not need to go to probate court for that. Now, what about your other personal property items that have value too? This could be jewelry, musical instruments, guns, whatever it might be. How do I get those into my trust so that my trust owns those assets? Well, this is going to happen through a personal property assignment. All of the assets that I have that don't have title or don't need a deed or anything, those are owned by my trust now. I'm assigning them them over to my trust. Sometimes you will specify them, sometimes you will make just a generic assignment of all of your assets. And that is how those assets get to be owned by your trust at the end of the day. Again, outside of probate, the trustee of your trust gets to distribute these assets when you pass on and die. Now, the trust is a critical structure you need to have if you have more than $500,000 of assets or you have real property. Now, remember in part 1 of the Estate Planning Masterclass series, I got into the benefits of the trust, avoiding probate, having more control from the grave. Now, a trust is going to cost you between $3,000 to $5,000 to set up. So I'm not recommending it for someone that has no money or assets. But if you have sufficient assets of $500,000 or you have real property, the trust is a significant benefit to you because the value that you're going to get out of it is going to be far more than $3,000 to $5,000 that it takes to set up. I hope this video was helpful to illuminate how your trust should own all of your assets. Now remember, this is part 2 of the 4-part Estate Planning Masterclass series. And my law firm Caicos Lawyers helps clients set up estate plans across the country. Whether you use us or another lawyer you trust, I just want to make sure you get this done and that you get a trust properly set up and implemented so that it owns everything. Please subscribe to my channel as well. I've got a lot of tips on saving taxes, protecting assets, and building wealth. I'm Matt Sorensen. We'll see you next time.